And I'll ask that um, everyone make their input on the poll questions. You can pick multiple answers from the poll questions so we can get a feel of your knowledge and understanding of AI with regards to ADR. And then we would have Alexander Bagahim to make his first presentation. And, the second speaker make a presentation. I will take questions after both presentations. So I think we'll just go ahead now with the poll questions. But before we do that, a kind reminder, please do not unmute yourself while we're speaking so we can get the best of our speakers. You feel free to use the reaction buttons at the chat box. If you have questions, please input your questions in the chat box. We'll take them at the right moment. So if you can have the poll question now so that it will be launched now so we can have our views. Thank you very much. So you can comment in the chat box if you can see the poll questions. We'll have about 3 minutes to answer the poll question. All right, thank you very much. I see Obiaja says she can see the poll question. So let's quickly have a feedback and responses on the questions. Thank you. So to be able to confirm that we've all done the poll questions, once you've answered the poll question, just chat in the chat box, just write done so that we know that you're done. Thank you.
Odunai, I think the poll was ended, and I think I might have done it abruptly because I'm also host, and I think I pushed on the wrong button just to make yes, the poll is no longer on. Can we put it again?
Okay, so we would relaunch it again. Thank you very much. Thank you.
And I won't touch anything this time.
Thank you, Alexander. So we'll launch the poll questions again. Okay, the question has been launched now. If you can see the question, it's just in the chat box. Let's get your response. And once you're done answering the poll question, you can just put in the chat box done so that we can proceed. Thank you very much. So we'll have 3 minutes starting off again. Thank you. Okay, I can see from the chat box that some of our participants are done with the poll question. Give a few more minutes for others to complete the poll question. And then we'll proceed. Thank you.
think we can end it now, and so that we do not can move on with the system.
Okay, thank you very much, Simi. All right, thank you very much. We'll share the results of the poll later on in the session. So going forward, without further ado, we'll have the first presenter, Alexander Vagahem, who is speaking to us on facts and fallacies, giving us an overview of AI and its current applications in ADR, the various ADR processes that we have. What are the myths and misconceptions about ADR, and case examples and demonstration of existing AI tools in ADR. Alexander Vagahem is the Vice President of Global Legal Data at Jus Mundi, where he leads the company's data strategy and global relations. Alexander is a French qualified international arbitration lawyer. Prior to joining Jus Mundi, Alexander has represented clients in a wide range of matters involving international commercial arbitration, international investment disputes, and French court litigation at the former arbitration practice at Castadil and Partners in Paris. In addition to his experience as a counsel, Alexander has acted as secretary to the Arbitral Tribunal in international arbitrations, as research assistant to the late Professor Martin Hunter at Essex Court Chambers, London. Alexander was appointed lecturer in international commercial arbitration, investment arbitration, and private international law with the LLM program of King's College and the University of Paris, and is the author of numerous publications in the field of international business law and arbitration law. Ladies and gentlemen, let's make welcome Alexander Vagahem for his presentation. Thank you very much. Over to you, Alexander.
Thank you very much for that presentation. Thanks for the invitation. I'm very impressed. We're already 46 in the room, so there is a lot of interest on the topic, and rightfully so, I would say. Maybe let me start by saying that I love that you put the song of Stromae at the beginning. Alors on danse. It's one of my favorite songs, and it's one of my favorite singer. And we also share the same origins. He's from Belgium and Rwanda, and I'm also from Belgium and Rwanda, and I'm also French. So I felt very at home and very welcome. So thank you, the Nook team, for that, even if it wasn't on purpose. All right, you gave me a big topic to discuss and to sort of set the scene. So it's a hard task talking about fact and fallacies, giving an overview of where we are, and do's and don'ts. So that's a lot to cover in 20 minutes. I will try my best to try to debunk some myths that we have around AI. I think what I would like, so you presented me. I work at Jusmundi. So Jusmundi is a legal tech with the mission to make international law and arbitration accessible, and we do that through AI technologies. And so we've done that for since our inception. And at the beginning, nobody was really talking about a lot about AI, although we were all using it in a form or in another. We were all using already some type of AI. If I just limit myself to the realm of legal research and legal tools that we're building, we were always using a type of AI that we can call, and sort of in a generic way, extractive AI. So that has allowed us, for example, to create tools to connect data with each other to make sure that those data were easily accessible. And I'll give you a few examples later when I show you the platform. But today, and I think the purpose of this webinar is mostly to talk about what we now call generative AI. And so by AI, I don't mean, and maybe not yet, as sci-fi robots replacing arbitrators or mediators. I mean software systems that can learn from data, recognize patterns, generate text, in a way that look intelligent to us. So in practice, most of us today, we talk about this sort of narrower form of AI, which are tools that are built to do very specific tasks, summarize documents, suggest various options, structure information, etc. We're not yet at a stage where AI is deciding very complex cases. Are we at a stage where AI can actually decide small value claims, etc.? That's something in the making, and we can discuss later. But from that perspective, AI is already very present across the entire ADR lifecycle, in mediation, in arbitration, in online dispute resolution. I'll give you a few examples, and since it's ADR, I'll also touch upon various other places, even though arbitration is probably where we are best placed to discuss. This is our daily practices. But in mediation, for example, there are already a lot of AI support tool. Again, no substitute for mediator, but they are here to sort of guide the parties' intake. They can help with sort of structured question, help people to frame disputes, detect main issues, etc. And so it's more a form of information management that you can have across mediation, negotiation, also arbitration, and for example, on summarizing long email exchanges, group issues, create timeline of events, extract sort of key interests and concerns from party statements, etc., etc. And we've seen already few very tech-savvy mediator working with various tools, and it's starting to prove very useful. There are also right now a lot of experiment of AI-assisted negotiation, and which are like tools that allows parties to sort of explore possible packages, compare options, calculate implication of different proposals that they are discussing within negotiated settlement, etc. So what AI is not doing yet, it's not doing a mediation, at least not it's not reading a room, it's not building trust. Again, I think this is very important to in those conversation to really separate the human skills from what the AI is capable of doing today. Now, in arbitration, AI has gone a bit further because a lot of the work is very intensive legal analysis. It's a lot of document handling, and these are things AI is relatively good at. And so the first major family of tool that we see in the sphere, it's AI-powered legal research tool and drafting assistant. Usmundi is one of them. And those tools are better when they are sort of accompanied with a database like ours. But you have different workflows and different categories of use cases. And so, for example, in our case, the AI system largely draws from search in large databases of words, court decision, treaties, rules, and then help you to get a first overview of a legal framework around a particular issue, identify relevant cases more quickly. You can draft initial version of submissions, procedural orders. It helps a lot with translation, for example. One of the use cases that we're seeing a lot used in our platform is because we have cases and jurisprudence in all the languages. The fact to be able to access those in your own language is a very useful tool, and sort of opening up now the access and a wider reach to materials which we wouldn't have necessarily have access to before. And so here, what you see is that AI is giving you a starting point. As counsel, of course, an arbitrator, you will have to check the sources, you will have to refine the arguments and decide, of course, what to rely on. Again, here I'm trying to make clear about the separation and how it is useful today, and how, in essence, you should use it in a way responsibly. I know we'll touch upon that with Emily after about really the how to use it. I think a second family of tool is mostly analytics. So it's really about analyzing large amount of documents, past awards, past decisions. AI can be helpful here to produce, for example, statistics, timelines, help maybe to calculate rate of success, pattern, etc. And so here you touch upon the analytical skills of AI in arbitration. Another area where we see a huge development of AI, and so we are, for example, very at the forefront of those, it's into case management system of mostly arbitral institution, court system, etc. Because here you can really leverage the power of AI in filing, tracking deadlines, suggesting procedural calendars, etc. And so we are at the moment having a lot of conversation with all the institution partner that we have today. And these are the conversation that we have. How do you integrate AI into case management system to actually streamline the process of an arbitral proceedings? And you have some experiment, I mean, if we want to touch upon that, about decision making. And this is, of course, a very touchy subject because it's a function that is human by essence. It is also very the sort of the heart of where the regulation touches at the moment. And you know, I was yesterday on a panel here in New York for New York Arbitration Week, and I was sitting next to a representative from the AAA ICDR, which is the American Institution of Arbitration and its international division, and they have released a sort of AI arbitrator. And it's not really an AI arbitrator. It's a sort of AI-assisted arbitration proceedings where you have a first draft, which is composed by an AI tool on very small claims, limited on construction cases, on a very limited amount of value, only document only proceedings. But it's not a decision rendered by an AI. There is an arbitrator who will analyze the decision and who will eventually correct it, et cetera, and then will sign it for enforcement purposes and become an award. So there are try, and this is where we, you know, there are of course discussion about it, and that has raised the ethical legitimacy question from a lot of practitioners, and happy to dig into that. I'm really passionate about those. But you can see the very sort of the transformative power of AI today. We see also a lot of use of AI in online dispute resolution. I won't touch too much upon that, but this is an area where actually AI is really powerful. You know, from filing a claim to classify to settlement agreement, prioritize case, etc., etc. And we see already a lot of application to it. So this is a bit of the overview in the various spectrum of dispute resolution. There are many other use cases I could touch upon, and AI has been used, for example, for document disclosure and et cetera for many years already, way before generative AI arrived. But I think there are few myths which we can debunk, and I will go through them one by one and sort of raise topics which we can discuss later on. So is AI going to replace mediator, arbitrator, or judges? I think for now this is, and we've touched upon it. Right now, most of the AI are support functions, and they help summarize document. They suggest possible settlement range. They draft first version of text. They help parties navigate, you know, do strategy and find and streamline and be more efficient in legal research, etc. But right now, this question of exercise of judgment remained a human function. And at least this is one of the value at Jusmundi that we have. We really build AI tools to support practitioners, counsel, arbitrators, experts, secretaries, and the entire stakeholders. But again, these are value that you can definitely discuss and question, but at least it's a value as from our stand, which is very important. The other sometime misconception, I think there is a lot of discussion around bias, etc., and this is a very important discussion to have, which touch upon limitations and risk that there is in using AI system. But so AI is not an objective or a neutral tool or unbiased. It's full of bias. It is full of bias from various layers. I won't go into details on that, but this is something that we need to understand and address. And I'll give you one example on our side. So we are building AI systems, and we have a database. Our database is composed of 130 languages, et cetera, et cetera. But the foundational and the LLM model that we take as a foundation to build on top our own AI system, they're mostly trained on English data, in English, American data in English, etc. So there is already an existing bias linguistically and also in terms of notion, which has a huge relevance for legal in the legal sphere. And so there is an evident bias which we're aware of. And what we do to sort of tackle that is that we inject our own biases into the training of the AI system. And so we're retraining across the languages so that it can perform in French, it can perform in Chinese, it can perform in Arabic, etc., etc. But so we inject a sort of international bias into the AI. So it's just to give you an example of really something that you need to be aware of, because this is important when you are using an AI system. And so this is just one example, but again, if we can delve a little bit further into that. Um, the question of how, some people think I don't understand how AI works, so I'm not going to use it. It's kind of the black box thing, or the other people say, oh, it's really advanced technology and I will trust it. So both positions are wrong, and they're because they're extremes. And I think where we are today is a sort of an understanding of a middle ground position. You need to understand AI at a high level, and this is why Emily and I spend a lot of time doing conferences, trainings around the world for lawyers to really, embrace and help. And very happy also to be here to have this discussion with you today. But there are very easy way for you to be assured about the use of AI. And so whether it shows sources, reasoning, etc., etc. So you don't have to be an AI engineer, at least not yet, but you need to be an informed user of AI. I think that's kind of a summary of where we are and a bit of a do's and don'ts. Where I'd like to maybe finish in order not to take too much time. If you're okay, I can show you very quickly Use Mundi platform and give you 3 examples, just to give you some very practical use cases of where we've built some AI and how it can be used. So give me 1 second. Let me just open the right window and I can show you all of that. All right. So this is Mundi. You can see all my screen? Yes, yes, perfect. So this is
Yes, we can see your
Mundi.
screen. Yes, we can.
Yeah, perfect. Thank you very much. Which is the AI agent for international law and arbitration. And so previously, Mundi was a search engine for international law and arbitration. And today, you have a coexistence of both, which are actually merged. And this is the most novelty that we did in September. We actually rebuilt everything from scratch. We started to include generative AI 2 years ago, when just a year after the first LLM models were out, and we did some try. We had a first version, and which was good, but not good enough for lawyers. We stopped, and we thought, and we rebuilt an entire new system based mostly on agentic workflow. Just to give you a sense, so this is Mundi, and this is UseConnect, which is a platform for the search for professional. So Mundi, you search for legal information. UseConnect, you search for professional. I even checked Emily's profile just to see, and you can see here. So these are all publicly available cases that we know about Emily, where she acted mostly as tribunal secretary. Disclaimer, this is by no means representative of her expertise. This is only publicly available information. Emily has a way bigger expertise than that, but it's what we were able. And so all of those information were able to be aggregated through AI. That's what I was calling you extractive AI earlier. I can show you the profile of someone else that we know in common with Emily. In this case, Maxi, who is a famous arbitrator and co-partner of Emily, has enriched her profile. There's a picture. She has added some cases. If we have, so there are a lot of functionalities here again that you can work on to give access. If I just take one example, So this is, and I'll start with the traditional search engine. I want to make a research on indirect expropriation. So this is a very famous issue in investment arbitration, as you know, and I'm just gonna query on the search engine how many cases I have, and you can see here I have like over 1,000 unpublished documents. And so what we did was that we merged both the AI and the search engine capabilities. And so the reason why we did that was to actually give control back to lawyers, because one of the main issue was that you actually, and so you can see here, I'm calling in the AI, and I want the AI to see among all those cases that are here, the 1,000 and etc., how many cases in this result discuss the economic impact requirement. So here you also can see I have two modes. So these are different models. So the think one, which I shouldn't have used because it's not a difficult query, it's a model which is calling a lot of agents. There is a planning agent which will try to break down the query, understand the query, etc. And then you have executing agents which are going to track across all those documents what are the ones which are discussing the economic impact requirements expropriation. Another thing, sorry, that you can see here also is the reasoning. This is something new that we've added precisely to tackle the issue of I don't know what the AI is doing. I don't know how an AI system arrive at a solution. And so here you have exactly the reasoning steps, one by one, of how the AI system is arriving at a particular query. So we're gonna run multiple query at the same time. Because it's an agentic workflow, it's not as quick as a ChatGPT request where you would have in 2 seconds something. And it's actually a good thing because you now have a much more intelligent and reason capabilities of the AI system, which will take a couple of minutes to go through a vast amount of cases and to be able to give you a much more qualitative answer. This is a very large prompt, which I will run also in parallel. You can see here, it's a very complex cases. Like the owner of a wind farm in Vietnam intends to claim against a contractor. I have a very specific fact patterns. I'm asking here the AI what contractual claims should the owner advance, what remedies can the owner realistically pursue, etc., etc. So this is a long prompt which will take a few minutes to go through. There is another example which I will also like to show you. Let me see if where are we on this one? Still searching. Another example which I would like to show you is what we call professional search. Sorry, I don't see it. Yes. So it's the ability to search on across professionals. So for example, a lot of people are asking us, because we have these databases of arbitrators and professional, one of the things that a lot of people wants to do is to be able to search to query and to understand, for example, how is Emily going to judge on a particular issue that I'm facing at the moment. And so this is a real, so we haven't released totally that features yet because it involves a lot of ethical issue. Because the AI system can literally give you answers. We don't want, for example, that system to be able to have a qualitative judgments on Emily's work. Is Emily a good arbitrator or a bad arbitrator? Is Emily, et cetera, et cetera. And so it involves a lot of really ethical issue which are difficult to tackle, and so we haven't quite released yet, which we haven't quite nailed down yet. But what you can do, for example, on Usmundi, again using the filter, if I look, for example, for here I have all the arbitrators and judges, and I'll take one, a famous Belgian arbitrator, a colleague So here you can see that there are 300 cases about him. So I have applied those filter, and maybe what I can ask, for example, in this case is so what we limit here is, so this is one of the query. Map the reasoning on bifurcation across documents, identify the test apply, and whether it evolved. And so here, basically, what we've limited the AI tools to do is to focus on the document, not on the person. We're not asking anything about Bernard Hanosio's performances, but we're asking it about legal reasoning applied in different documents that he was involved in as an arbitrator. So for now, it's very limited. For example, you won't be able to ask the AI, give me a list of potential candidates for a case among various criteria. It is not made for it yet, but we're working on it. And this is something I was discussing yesterday, because again, here there are bias issue. Like for example, because the training data has such a bias, so for example, it's a predominantly male, predominantly white, etc., necessarily the AI system will replicate that. So how do we actually sort of rebalance that by, for example, asking it to provide female profile or representation from various countries, from Africa, APAC, Latin America. And so again, these are a lot of ethical issues which we're dealing with at the moment. So you can see here the first example. So from the case, and you can see how I merge like research and AI capabilities, again, to give you back the control. You have here all the cases that discuss particularly this economic impact requirement on indirect expropriation. Let me see if my other prompts work. So this one, yes. You can see here that very, very long and complicated. You can always find the reasoning here just to make sure that the AI arrive at that. But here you have like a first sort of strategic draft into a kind of a technical prompt. Again, you need to have some type of prompting technique and exercise. These are all things that you can learn. You always have here the sources, which are quoted from the documents, and you can go here and see the relevant paragraph of each document so that as a lawyer, you can analyze directly each sources from the document. But you can see here how impressive that is. And here I also have my answer on, again, limited to Bernard Hanosio's cases in which he was involved. And I have here all the way the test and the criteria he applied in terms of deciding whether to bifurcate or not proceedings. And I have that in the form of a table, etc. All of that in in a very short amount of time. I'll stop here. There would be like hundreds of other use cases that I could show you. I didn't show you, but you can upload documents, and I had like a huge set of document prepared where you can have the AI analyzing each document, creating tables. I mean, you can see what you can do in a very few minutes on very complex legal issues. I'll stop here for the moment, but I'll be very happy to continue that conversation after Emily's presentation.
Thank you very much, Alexander, for that beautiful presentation on AI facts and fallacies. At this point, I'd like to find out if Emily wants to jump in, make a comment on what Alexander has presented for us as well.
And nothing specific. Thank you, Arden, and thank you, Alexandre. That was super interesting, and I think it's always very interesting to see visually, even if it's I'm the test bunny here being profiled, but very interesting to see how the tools look in practice, and I think very useful for the audience. So shall I proceed?
All right, thank you very much for your contributions. Yes. I just quickly like to read your profile. And Emily Hay is the managing counsel at ARB Boutique, an Australian qualified lawyer based in Brussels, and the co-chair of the ICC Commission Task Force on AI in dispute resolution. Emily acts as an arbitrator and counsel in international arbitration proceedings with experience across diverse sectors, including nuclear energy, hydropower, fuel cell technology, oil and gas, satellite, banking, construction, medical devices, real estate, consumer appliances, and aviation, with expertise in new technology, data protection, ESG, and renewable energy. Emily has also advised on emerging areas of dispute resolution, having lived and worked in Asia, Australia, Europe, and the Middle East. Emily brings a truly global perspective to practice, recognized by WHO legal since 2021 as a future leader in arbitration and named a global elite thought leader under 45 in 2024 and 2025. Emily continues to distinguish herself as analytical in her approach and commercial minded in decision making, one of the leading arbitrators of the future, and an expert in data protection and technology. Everybody, let's make welcome Emily A. Thank you very much. Over to you now.
Thank you so much, Odun. That's really a very kind introduction, and thank you to the Neutrals Nook for the invitation today. It's a real pleasure to be here with everybody. And thank you again to Alexandra for introducing all of the ins and outs of AI and where we are at. I think it's no less ambitious to try and consider where we're going from here and the future opportunities, some of the risks and challenges that we face. And again, difficult to cover it all in a short time, but we can start and continue the conversation. So I wanted to look first at some of the emerging trends in AI and their potential impact on the practice of ADR. I would say, like Alexandra, my focus is arbitration, but some of the things I cover will equally be applicable to mediation and other kinds of ADR as well. It's sort of, where do we start for emerging trends? AI is an emerging trend itself, and within the use of AI, you have so many emerging trends, some of them more rapidly than we can keep track of. But let's talk about a few of them. Obviously, agentic AI is one of the emerging trends beyond just generative AI that Alexandra introduced, and you've already seen a little bit about how that works. And this sort of more autonomous working with AI, I think, is going to be seen more and more adopted in practice. And this obviously has implications for the kinds of use cases that we might be able to implement in our work. And we have to think already about that next step, when I think there are a lot of generative AI tools out there. And we already have to think about, when we're trying to regulate the use or think about how we responsibly use those tools, of how does that apply in the context of agentic AI as well. And I think one of the important developments as well that Alexandre also mentioned was the adoption of AI by institutions, especially this new AAA ICDR AI arbitrator. This is just become available this month in November 2025 for documents-only construction cases. And that's a very interesting development, I would say, because it really goes to the heart of one of the more complex use cases in the ADR field, which is ones that implicate or are at least adjacent to human decision making, without replacing humans, of course, but it goes further than some of the use cases we have so far. So that's an important development. I think another emerging trend is just the sort of number of tools that are available on the marketplace are exploding, changing very rapidly. And even in the last year, you can have demos with one company, and 3 weeks later, you have an updated demo and they have new features, new tools available. Things are moving very rapidly. And you have not only legal sector-specific tools, but dispute resolution sector-specific tools, and not just dispute resolution-specific tools, but ones that are catering to counsel practice, ones that are focusing to arbitrator practice, and ones that are used mainly by big firms, but also ones that are targeting boutique and independent practitioners. So there's really a huge wealth of options out there on the market that's really makes a difference, and sort of looking at the use cases that are going to be helpful for us to adopt in our work, but also some of the things that are really important for lawyers, like security and confidentiality of data, to ensure those are sort of built into the design of the system, obviously trained to do legal tasks, and also to address some of the issues that we have around sort of the black box of AI, where now I think it's fairly common practice to have the source materials highlighted and hyperlinked, and you can very easily normally see where the AI has drawn a particular statement from and interrogate it, which is really important to be able to supervise the output of these tools. So all of these things that are sort of very tailored and suitable for legal use are very interesting developments. I think the rate of adoption is increasing a lot, not just by lawyers, but by people in their everyday lives. Adopting AI to optimize all sorts of tasks and in all sorts of businesses and industries as well. And I think that also changes the conversation in ADR, because when you have your clients using AI in their daily work, when governments are using AI in integrating it into their practices, obviously the user expectations change. And users are going to expect that lawyers are also optimizing their time and their costs on the matters that they're working on, while still providing or even increasing the quality of their services by using AI. So I think this change all around us drives us forward as well. And I think another emerging trend is as we continue this adoption and the changes are developing rapidly, the conversation around the regulation of AI is also evolving very quickly. You have more and more guidelines. Many institutions have released institutional guidelines or principles around the use of AI in arbitration. You have the EU AI Act, which is sort of rolling out and has very important implications for AI that might be used, especially in decision making. And you will have sort of maybe more targeted or sector specific regulation also across different jurisdictions as well. So I think this regulation and guidance is really important to build trust in the tools, to help us shape responsible use of the tools. But it's also a challenge to keep track of it as it evolves, and to make sure that we are, compliant with those regulations as they come out. There's also obviously the ICC Commission's task force on AI in dispute resolution, which I'm a part of, and other institutions as well. And the IBA has a task force underway as well. So there's a lot of thinking going on. I think that's essential. We really need to keep on top of the technology and keep an active conversation between technologists and lawyers to make sure that we're shaping and using the technology that will be the best for our future practice. So these are some of the issues. I wouldn't say that this means we're arrived at a crystallization of what best practice is. I think there are some very big open questions, and it feels a bit like you just get your head around, okay, this is where we're at, but the goalposts keep moving, and they keep moving quite quickly. So we're having a lot of conversations around, institutional initiatives and working groups around the world around, what is appropriate use of AI in what contexts and by which participants in arbitration and ADR proceedings. And we don't always arrive at common ground yet. There's not full harmonization, for example, about disclosure of AI tools. When should you or must you disclose the use of AI? What kinds of use of AI is completely permissible by arbitrators, for example? Are counsel at complete liberty to use AI without any kind of disclosure in an arbitration proceedings? And some people have very clear answers to these questions, but not everybody has the same answers to the questions. And so that's a conversation that I would say is still ongoing. Then looking at some of these challenges that we face around the use of AI, you have ethical, procedural, human concerns. And some of these Alexandra highlighted as well. So bias is a really important one. And I think that's one it's a real challenge on the user end. I think it's very important to be aware of bias, but it's not, and to have sort of more tools to be able to recognize it and, if possible, to address it. But it's something that really needs to be built into the tool to start with, to address bias. And sort of ways of auditing or checking the bias of a tool. I think we don't have so many at our disposal at the layman's end yet to address that. So that's a really important challenge that still remains to be addressed. Some of the other challenges that we face, for example, confidentiality of data. This is quite a user issue, I would say, in the sense that there are all these tools out there and some of them are freely available, but as lawyers, we are not free to just put any kind of information into a publicly available tool, which may be used, to train the tool. It may be disclosed in jurisdictions that it should not be, and it's your client's confidential data. So there's a lot to be done for training lawyers about responsible use of AI tools and using legal specific tools that do respect confidentiality in a way that's compliant with our own legal professional obligations. And that can really involve reading the fine print, because it might not be obvious at first sight whether a tool is appropriate to use. It can also be something that might need to be regulated on a case-by-case basis in a particular arbitration proceeding. I think there are some cases in which confidentiality is already coming up in the use of AI. There's also the question of sort of oversight of the output of the AI in a way that also respects your legal obligations, of your professional legal obligations. So, for example, if you are using an AI product that's not appropriately supervising it, and you end up submitting authorities to a court or a tribunal that are not accurate or don't even exist, this is a big issue as well. And so one thing is, again, around training lawyers around supervision of the AI tool to ensure that we can verify the output. But it may be that these are things that are also sort of addressed in procedural measures that an arbitral tribunal might take at the beginning of the case about, okay, this is going to be a permissible use of AI, so that everybody's on the same page. And these are things that we're not going to do in this arbitration proceeding, for example. So some challenges can be addressed in this way, either by designing of the system or procedural management or training. And I think the one sort of fundamental question that everybody comes down to eventually in the AI conversation is, okay, but what about when it comes to making decisions, and where do you draw the line when it comes to decision makers using AI? When are we encroaching upon the mandate of that decision maker to reach a decision? When is it no longer their decision as a human being, but more like a result of an output reached by an AI that may or may not be rubber stamped by a human? And these are conversations that really go to the heart of the administration of justice. I think it's really important to preserve the human element of our decision making. There are, of course, circumstances in which we may wish to delegate our decision making to technology, and I think that will exist for sure, and it may or may not be considered arbitration when that's available. And you see a sort of hybrid model now by the AAA ICDR, where it's not it's a human decision that's being made, but it's being made with a first draft prepared by AI, and it's sort of there's a spectrum here of human involvement, and I think it's a conversation that we need to really be having actively in the profession is, where do you draw that line? What's a permissible use of AI when it comes to decision making? How are we going to regulate that? And how do you ensure that that where parties in particular are choosing for a human to decide their dispute, that it is a human that's taking responsibility for and has produced the outcome in question? So I think that's a really important question, because you do have questions of over-reliance on technology. If there is an AI-generated solution that has been produced, it sort of creates a bias in itself towards that result in the mind of a decision maker, that it's on the paper there, like, who am I to say that AI got it wrong, sort of thing. So I think, especially when it comes to high value and complex and international disputes, that the sort of human element of decision making is something that's going to be preserved and carved out for quite some time yet. But we are going to see more and more use of AI, and I think you can draw some parallels here with the debate around the use of tribunal secretaries by arbitral tribunals. So for many years, the debate in international arbitration has been when should you use a tribunal secretary, for what tasks is it permissible to use them, when would it be impermissible in the sense that you would be considered to be delegating your decision-making functions to a secretary, and that's sort of a red line. Now, these days, everyone's more or less on the same page about what's appropriate and inappropriate use of tribunal secretaries. Every institution more or less has a guidance note about the use of secretaries and procedures by which you can validly appoint them, conflict check procedures in place. And I think a huge part of the success of that debate has been transparency around the use of secretaries and a bit of harmonization without needing for everyone to be using the same guidelines, but sort of some common principles that emerged around the use of secretaries. And I think the analogy goes so far, it doesn't go all the way. A secretary is a human and AI is not, but in the sense that insofar as we're concerned with preserving the human decision-making mandate of an arbitrator, I think the regulation should focus on transparency as well. We need to be talking about the use of AI. We need to be, being open about the use of AI so that everybody's on the same page, and we can, see some crystallization of best practices that will help us to have the regulations in place that make the most sense. So that, I think, is the point of the regulation, really, that when you use AI, you use it properly, and that we preserve the human decision-making mandate, and also that we preserve the enforceability of the award, which is fundamental to the success of arbitration. So I think these are some of the highlights of the risks or the challenges that we're going to face. So how do we sort of strike this balance between technological advancement and human judgment? I think it's not really a choice of one or the other, because we have to do both. We have to advance technologically, and we have to continue to exercise our human judgment. And I think if technology is used appropriately, it can improve, I wouldn't say our judgment, but it can improve the services that we provide and leave us more freedom and more time to dedicate to the important tasks of human judgment while preserving this human side of justice. But it may not look the same as it has always looked to us. And I think all of us working in our careers right now are still going to see many years of quite fundamental changes ahead. This is just the beginning of the road, and the kinds of options that are going to be available to resolve disputes are going to look different. We already have a huge amount of information available to us that was not available to previous practitioners. And as you've seen Alexandra just pull up the kinds of statistics you can develop and the data that you can mine to know more about the way that disputes have been resolved is going to help us to better resolve disputes going forward. And I think that's going to continue to evolve quite rapidly, and will sort of change the way that we have settlement negotiations. I think in terms of ADR options, that gives huge potential for sort of knowing what sort of outcomes might be likely in a particular kind of dispute, and to help parties really get to the table and talk about ways to resolve their disputes. So those are some of the key points, I think, going forward.
Thank you very much, Emily, for that beautiful presentation. I mean, I've heard you say that, yes, arbitration, the use of AI is very key, but even using AI tools, we have to be also very careful, because the issue of disclosure, confidentiality, which is one of the bedrock of ADR, one of the ADR mechanisms. So, Alexandra, do you have any comments to make on Emily's presentation?
A lot. No, frankly, if you look at the recording, you would see me nodding at everything Emily was saying. I was like that, nodding. I agreed with everything that she mentioned. The analysis was impeccable. I think you were very humble because I think you're chair of the ICC Commission, and so it's safe to say that we're in good hands, at least on that reflection at the ICC Commission front. No, I think you're totally correct in mentioning this is just the beginning of the road. There is we really believe it's a huge transformative journey in which we all are, not only the arbitration community or the legal sector, but I think it's worldwide, and we're yet to see where goes. And this is where those discussion around ethical use or critical. I've seen few questions about that. But this is really at the heart of it. How do we ensure collectively to make the best of the use? Because of course, as a very powerful tool, it can be used for the wrong reason or for the right reasons, and so that's where it is very important for us as a community to come together and first learn how to use them, and so that's more our job, and understand the way to use them, and this is more the the work of thought leaders and regulation and association such as the ICC Commission or the IBA, who are really working on those particular aspects.
All right, thank you very much for your contribution. So we have a few questions that was posed in the chat box. The first question we have here says that is there a data privacy component, or are all the information available publicly and accessible? I think this question was asked when Alexander was making this presentation regarding AI tools. The components of this AI tool, the information they be accessible to everyone, or there's some restriction sort of to the access of the information?
Yes, it's a very good question. There are many things we didn't really touch upon in a much deeper level. Emily mentioned issue of confidentiality, security, privacy, data protection is of course one of the big point also. These are really very important point, especially when you're looking for a provider. You need to make sure, and if I just jump back on, for example, security, what does it entail? What does it mean to have a AI tool that is secure and that is protecting confidentiality? And you need to look at various technical points, which is, for example, the data retention, how long the data is retained in the system. Are you using the data to train the model or not? As a lawyer, you should use only tools that are not using the data that you're inputting to train the model, unlike the publicly facing ChatGPT and others. Again, this touches at the heart of your duty of what we now call the duty of diligence, the duty of competence that you find in the various regulation around the use of AI that they are now. And privacy as well is another very, very important point. On the data protection aspect, it is critical. So for us as a database, this is like our Bible, like the GDPR, because we are in Europe, but any privacy kind of regulation are very important to us. It's really the way we process data generally as a database, but also more particularly as how the AI is processing data. So most of the time you have different legal bases, either consent, legitimate interest, or for example, in our case, it goes mostly on we sort of acquire consent through partnership with arbitral institution who in their own rules have provision for publication of such and such information, etc. So yes, there are a lot of data protection and privacy issue to be touched upon. And as a data subject, you have many rights, which we inform everyone of, and to be able to be in a position to actually exercise those rights. These are indeed fundamental rights, and with they have a particular resonance when you touch on the AI front. But yes, great question. I stop here because this is really like the topic of an entire 1 hour session that we could do with the Nook team.
Thank you very much. So, because a comment and a question here for both presenters. Comment says that both your presentation touched upon the profound changes and ethical issues surrounding AI in ADR, a major concern in algorithm bias, which can stem from skewed training data, and flawed design, potentially undermining the core ADR principles of neutrality and fairness. So the question, how can the ADR community, including institutions, developers, and practitioners, proactively identify, mitigate, and remain accountable for potential biases embedded in the AI tools used for case evaluation, document analysis, or ODR platform designs? So I would like Emily to start off, and then Alexandra, you can make a comment on the question. Thank you. Over to you, Emily.
Thank you. This is another great question, and I
Good
can't
luck.
say that I can answer this. And if we had this available, it would be answering one of the very big questions that we have around the use of AI. So if anybody has the answer, please do share us. I think this is something that we're all looking for right now, is what kinds of measures you can put in place to benchmark tools, or to have ways to sort of audit these tools, to be aware of the biases that might exist, and then to know what we might be able to do about that. And these are exactly the kinds of questions that, you know, initiatives like the ICC Commission and the IBA Task Force, I'm sure, are considering. If Alexandre has figured out, I will ask him now to share it with us as well. But I think it's a really important question, and one that we need to be aware of and look at ways to address.
Nothing further to add. I think this is a path we are all here at. We are all on at our different level, and of course, as you know, I gave the example on bias earlier on. There are technical ways in which we sort of tackle that issue from a technical standpoint. But you know, and usually when I do sort of trainings on AI and that I try to explain bias, I explain them also like with a metaphor about the human bias, which is, you know, we all have, as humans, we all have bias. We have bias from coming from our family. We have bias coming from our social environment. We have, you know, and so the same applies to an AI system. And so it's a question of really learning curve, knowledge, and sort of ethical decision in the way we build products. And we also share that information with the community as a whole to make sure that this is a sort of a collective journey.
Thank you very much, Alexander, for your contributions. So the question directed to Alexander again. You mentioned that an AI arbitrator was launched for the first time this week. So the question is, in what ways does this development impact the arbitral process? In the course of your presentation, you mentioned that an AI arbitrator was launched for the first time. So in what ways does this development now impact the arbitral process as we know it to be?
Yeah, and both Emily and I we mentioned that this is the first initiative. I think it was so the Emily corrected it and put it in perspective. It's not an AI arbitrator. It's an AI assisted arbitration through sort of delivery of a first draft of document analysis by an AI system, validated, amended by a human, so that it ends up being an award made by a human. So it's a AI assisted arbitration. It's not a AI arbitrator as it is marketed. So we need to be careful of that. But is there a time that small claim value, repetitive claims, there are already trial even in the court systems of many countries. For example, even in France, there is you have very small claims which do not necessitate any type of decision. It's just you have an invoice and then you have an injunction to pay. These are taking a lot of spaces in court, and they can be addressed very easily through an AI system because it's just really validating the correspondence of a claim with a various amount, etc., etc. So there are already trials around the legal system of various countries to actually sort of evacuate a lot of those small claims through various AI systems. So here we see very concretely decision making being delegated to an AI system, and Emily touched upon that also in various forms. Is this something that can be replicated to arbitration? Are we going to see, you know, low value claims being delegated to AI system. Are we going to call that arbitration, or is it going to be something totally else? Again, Emily touched upon that earlier. These are questions. These are real questions. For today, we're not there yet, but you know, again, the technology advanced very rapidly. What we were not able to do 2 years ago in terms of quality of the output that I showed you, today we're able to do it, and in a very, very impressive way. So.
All right, thank you very much. So we have one more question. Says here, on the issue of bias and flawed designs or likelihood of confidential breach in using such information to train AI in ADR, do you think the conversation on policy formation would be better driven as a global, regional, or an ADR institutional conversation? So Emily, would like to take this?
Sure. I think it probably has to be all of those things, all at the same time. And I think it is happening at all of those levels as well. We can't just do global and ignore regional or institutional level. So I think there is some level of frustration at the moment that then you have sort of regulations or guidelines spitting out from many different places, and it's hard to keep track of them and hard to keep them aligned. But I think we do need to combine forces globally. It is a global issue that's impacting on practices in a way that's relevant across jurisdictions. So there does need to be a global approach, but we cannot ignore the impact of local law, which, for example, can impact on the enforceability of an award. And if you have a lovely global standard, but it's not aligned with something that might be considered public policy in a particular jurisdiction, or is inconsistent with the mandatory law of that jurisdiction, then it's not going to be of much practical relevance either. So I think it may be too optimistic to hope that we land all in the same place. I think we might end up with different regulations in different places. And so it might have to be a combination between a global approach, but then taking account of regional and local nuances.
Thank you very much, Emily. I think, Odo, are you back? We can't hear you.
Yes.
Okay. We're
I'm back.
for
Thank you very much. All right, thank you very much. So I have one more question that I would like to ask. I'd like to ask Alexander this one. I have two questions rather. So how can practitioners, ADR practitioners, prevent the reliance on predictive analysis? You mentioned the tools and what these AI tools can do. So how can practitioners prevent the reliance on predictive analysis, historical outcomes from creating a settlement ceiling or floor that discourages creative or precedent-setting solutions in mediation or arbitration? So,
it's an interesting question, very specific, which, if I understand correctly, that is to say that basically there is a fear that by being able to predict outcomes, then you might end up, not forcing, but encouraging settlements, and then there might be some kind of lack into creativity of decision making
yes,
of some
yes.
sort, because you're relying on the same sort of data set and precedents and just repeating something.
Yes.
And I think it touches upon what we've discussed also about biases, and it's really that it's at least when you're talking about the training data set, and also when we talk about selection of arbitrator, if we don't put into action some very strong guardrails, we will just repeat biases which are inherent to the training data set. And so, for example, if I'm asking an arbitrator in construction cases on an AI tool that is not fine-tuned and trained and appropriately thought well, you will have the same list on and on of the same people, because those are the people that has most come up in cases, and so you will just replicate it, that bias which we have been for years trying to fight, and trying to amend and infuse more diversity, etc., etc. So I think you're right. This is a risk, but this is not something that is inevitable. That there are tools. First, being conscious about it as a community. That's the first point. Second, on our side as a legal tech provider, there are technical guardrails that we put in place so that we do not replicate the limitation inherent to the training data set, either by putting more diverse data so that the AI tools can be trained to have a much more sort of diverse palette and capabilities of answering across languages, across issues, across systems, common law, civil law, etc., etc. So there are ways, but it's true that it's an important issue to be aware of. And again, the same point that we've discussed over, the knowledge is key. And so the fact that you have that knowledge allows you to be able not to be a victim of those risks, because there are risks associated with the use of AI, and that's one of them. And you don't need to be scared about it, but you need to be aware of it so that you can use it in the best way and the best ethical way possible, and understand that, always challenge an AI output, precisely because there can be some type of ceiling linked to the limitation of the training data set on the various issues that you encounter.
Okay, thank you very much. So, one more question for you, Alexandre. Given the documented risk of hallucinations and the need for stringent verification, how do ADR providers vet third-party AI tools to guarantee the accuracy and reliability standards necessary to avoid jeopardizing the integrity of the resolution process? So I take it again, or did you get the question?
No, it's fine. I understood it. So, I mean, this is really the question of quality is at the heart of what we do. This is why we released the new version in September of USAI, because precisely we knew that the quality and was not to the standard of an ADR practitioner, because the legal reasoning is so nuanced and so essentially human, that it's hard to get the good result, and which is also a good point for us. We do benchmarking, we do testing, we evaluate the quality of the outputs, etc. So that's what we do. But then there is the user side, and this again is the conversation we had about being able to verify, to challenge the accuracy of the output. That's why, and as Emily explained, you have now, and I showed you also, sources, which gives you directly the exact output, the exact sources from which the output is generated. And that allows you to be in a position to verify and to assess the reliability and the usefulness. Today, hallucination is part of the creative process of an AI tool. So it's not the AI is great precisely because also there are hallucination. This is part of that sort of creative process that makes the AI able to generate human-like text or video or audio output. And so this is part of the way it is. Then what you do is usually the way you're building it with the data set and the sources, how you retrieve them, etc., that improve the quality. And today we have a very, very high quality score. It's more a question of accuracy than hallucination. Whether it's accurate, are the sources selected the right ones? Should there be other sources that should have been selected by the AI? So these are the type of sort of quality issue that we have today, as opposed to blank hallucination, i.e. made up cases and stuff like that, which you have if you're using ChatGPT, of course, because there are no safeguard, no guardrails. So please stop using ChatGPT when you're doing lawyers' work. I implore you, use appropriate tools, check security settings, check quality, check confidentiality, privacy, etc. If there is one thing that I would like you to keep with you after this webinar, is that yeah.
Thank you very much for that insightful contribution. So I have two questions for you, Emily. I'll just take them together for sake of time. So the first question is, what is the single most critical, non-negotiable policy guardrail that institutions must adopt now to protect due process and client confidentiality when deploying high-risk AI tools? That is a mandatory human veto, such as mandatory human veto, algorithm, and auditing. And my second question is, given the call for global policy harmonization, should regional ADR institutions prioritize adopting international risk-based standard voluntarily now to preempt conflicting regulations and ensure international enforceability? These are my two questions. Did you get them quite all right?
Yes, I did. Thank you.
Thank you.
I would say the most critical policy guardrail is really human oversight and supervision of AI output, and that applies whether you're counsel or arbitrator or institutions. That really we need to be clear that humans remain responsible for, and lawyers remain responsible for their work product, whatever that may be. Institutions remain responsible for their decisions, and so that sort of responsibility, I think, is a good guiding light. It may not be enough for every single use case or scenario that we're talking about, because sometimes it's just not permissible to use AI at all for particular kinds of tasks. And so it's not enough to say that a human is supervising the output. It may, especially when you're talking about decision making, it may not be appropriate to use it in every single case. And I think that's where we're getting down to the nitty-gritty of some of the rules and regulations that we're looking at now. And in terms of how to prioritize standards, I think we touched on this also, that really these global efforts are underway and they cannot ignore either regional or local considerations. And I think that's the way forward in order to make sure that we preserve the enforceability of awards. So institutions have quite a dilemma here to keep abreast of all of these developments and the technological changes themselves, and perhaps subscribing to the international standards that are out there. I think one of the most detailed standards that there have been developed so far is the Chartered Institute of Arbitrators guidelines on the use of AI. Many other institutions have some guidelines as well, and you have the Silicon Valley ones, which were very early and very instructive as well. But I think the Chartered Institute ones are the most detailed. So I think those are a really great and practical guidance that we have already in our hands. And maybe that's the prudent approach, is to look to them now and to continue to monitor the developments, because there will be more certainly in the future.
Thank you. Thank you very much. Thank you very much for that comment. So at this point, we'd like to take, at the beginning of the webinar, we took a poll question. We'd like to take another poll question. Given all that we've heard today, your feedback on your responses on the poll questions, you can select multiple answers. So as you get the poll questions, please feel free to answer and let us know in the comment section once you're done. Can we comment the poll question that's been launched? Can we see the poll question? Once you're done with your responses, please let us know in the chat box that you're done. Thank you. Okay, so while we're taking the poll questions, I'd like to get the last words from our presenters. Do you have, Alexander, do you have a last word, comments to make?
Thanks for inviting us and for inviting me. It was great. I didn't have an occasion to have a conversation also on that with Emily, and I was very much looking forward. So thanks for giving me that occasion. No, I think it's and all the questions shows the interest and that there is on the topic, and the concern and engagement and or excitement sometimes. And I think even the polling question are quite well done, and you can see already the first result. I think there are no right or wrong answer in those poll question. It might be just question of prioritizing and categorizing, but yeah, very engaging. Thank you.
Thank you, Alexandre. Emily, in the last words, a comment from you.
Thank you also from my side. It was a real pleasure to be here today and to discuss these issues with Alexandre and with everybody here. And thank you everyone for the fantastic questions. And I think the main point is we can choose, the way forward, but we can't choose not to engage with AI. It's here and it's happening. And I think everybody here is doing the right thing by coming to engage in this conversation. So I look forward to continuing the conversation with all of you.
Thank you very much, Emily. Thank you, Alexandre, for a beautiful presentation. I would say that our participants today have been able to take it, to home, and then would put all these things into play. Right now, I'll hand over to Simi for comment to closing remarks. Over to you, Simi.
Thank you. Thank you very much, Odun. Thank you. I want to really appreciate our speakers for the insightful presentations. We've learned a lot today. I'm very grateful. Thank you to our distinguished moderator for a job done. Thank you very much. On behalf of the Neutral Nook team, we appreciate everyone that could be here today, all our participants. We had over 50 people join us today, and there are still 49 people on the call. That means that we must have done something good today. Thank you very much, everyone. We'll be announcing our next episode on our LinkedIn page. So please follow us on all our social media platforms. And this episode too will be uploaded on our YouTube page and on Spotify. So you can later rewatch, to learn and get those things that you missed out on during the session. Thank you very much, everyone, and enjoy the rest of your day. Thank you, Emily. Thank you,
Thank you.
Alexandre.
Bye-bye.
Bye for now.
Thank you, Neutral.